the best informed decisions for themselves and their family. At Haymon Law Office, we protect your brand, your businesses, and your family. As Ms. Sims said, there are various areas of the law in which we practice, but today we are going to talk to you all about estate planning and going over the basics of estate planning, what that is, what that looks like, who needs an estate plan, what does it do? So without further ado, Ms. Sims, should I go ahead and get started with the presentation?
Yes, you can go ahead and get started. Thank you.
Thank you.
And guys, if anyone has any questions or anything, go ahead and just either type something in the chat. That would be awesome, or just kind of let us know, and then we can ask those for Ms. Haymon. Or you can wait until after the end to see to ask her any questions for Attorney Haymon. Thank you.
Thank you. So let's just get into it. So who needs an estate plan? And we'll elaborate more about what an estate plan is as I go into the presentation. But just to start, let's make sure you qualify to even be in the room today. So who needs an estate plan? Everyone. So if you're alive and you're over the age of 18, you need an estate plan. It doesn't matter if you're single, you're married, you're divorced, if you have children, you don't have children, if you own property, if you don't own property. We highly recommend it if you have a business or if you have any assets at all, bank accounts, anything. So if you're over the age of 18 and you have any tangible item, a vehicle, bank account, you need an estate plan. And we're going to walk you through the reasons why you need an estate plan today. All right, so what is an estate plan? Okay, so people think, I don't need an estate plan. I don't have a big house on the hill or anything like that. But an estate plan is essentially a way to remain in control of your property and assets in the event of your incapacity or death. Meaning if you get ill and you can't make decisions for yourself, you want to be sure that you still have control over your property and assets. When you pass away, since you're unable to communicate your decisions, you want to be sure that all your requests are in writing. And that's essentially what an estate plan is. And it's also a way to properly transfer your assets to whom you want to inherit after you pass away. So, if you have a sister that you want to specifically give something to, or your children, you want to make sure this is recorded. And generally, I have conversations with my clients, so it's more than just documents, right? It's a conversation about your assets, what you have, what your intentions are, and then we put that all into a series of documents and directives to outline and plan for your wishes, so that not only your physicians know how you want to be cared for, but your family knows your wishes for your assets or your body. And I look at this as a holistic and encompassing plan for your future. So we don't just sit down and write a will, and we'll get into the terminology and different pieces of estate plan later, but it's very holistic and encompassing. So we want to know about your life. What have you acquired over your life? What have you lost? Are you in debt? Do you have student loan debts? We really want to know this so we can help best plan for your future. And also, you can look at an estate plan as a way to plan for your retirement outside of traditional methods. So some people don't have that 401k, IRA set up because they may have been self-employed or switched jobs, but you can speak with an attorney and financial advisor to ensure that you're set up for retirement. So what is an estate in particular? So again, an estate isn't that big house on the hill with the gate and all of that. It's actually assets. So if you think of an estate, think about assets. What do you have? What is titled? If you have a vehicle, if you have real estate, if you have a home that you live in, if you have any household or personal possessions that may or may not be titled. If you have a checking or a savings account, IRAs, if you have life insurance, those all go into your estate if something were to happen to you. So when you think of an estate, think about what you actually own. What's in writing? What have you contracted to have? And that is your estate. So what happens if you don't have an estate plan? So if I don't sit down at all and don't talk to anybody at all about this, what can happen? What's the worst that can happen, right? Worst that can happen, I hear a lot of times, well, my kids will just get all my things, or my husband, it'll just transfer to my husband. But that's not always the case.
Mm-hmm.
The biggest thing that I see happen as an attorney is probate. Probate, whether you're incapacitated or whether, you pass away. Probate. And I'll go into more of what probate is, but it's not a pretty word, and we'll go into why it's not so pretty in a bit. But you want your property to be transferred according to your wishes. So in probate, there may be the possibility that your property is transferred outside your wishes. Or in the alternative, if nothing goes to probate, there's still that possibility that it's transferred outside of your wishes, and we'll get into more of that. Also, you want to be sure that you set up your incapacity wishes and final plans, because you may have certain desires for your last wishes, and you can't communicate those, and someone else may have thought, well, oh no, he didn't want to be buried, he wanted to be cremated. I've heard that story. And then families are fighting on, your final burial plans.
Mm-hmm.
And maybe that's not what you wish. But if you don't have it in writing, then no one knows. And that brings up the next thing, family feuds. I see that happen all the time. My husband said he wanted this thing, and then the daughter comes back and said, no, dad told me he wanted this. But dad can't communicate that anymore. So in order to avoid that, we want to be sure that you set up an estate plan. I've seen instances that houses have been foreclosed on after the passing of a loved one, because an individual couldn't come in and just take over the mortgage because there was no transfer of that property, and no one paid on that property. So that family home that has been in the family for 3-4 generations is now gone. Also, it could be difficult for your family to wind up those affairs. So, if you're incapacitated or, you pass away, your family, they're going to be devastated. And it's hard. It's hard working with those families as an attorney after a death of a loved one, trying to wrap up your financial affairs, your personal affairs. That's the last thing they want to think about when they're trying to mourn. And then with probate, and we'll talk about this a little more, there's no privacy regarding your financial affairs if you don't get it in order now. So I often hear, well, I don't want to get an estate plan because I don't want people in my business. Well, if you don't, people will be in your business. It'll actually be a matter of public record in probate. So that's something to consider. So I just want to hop into what an estate plan can encompass and the different documents and what those look like. So the first one that you hear about or you see on TV is the last will and testament. And oftentimes you see some attorney and he's standing there and he's reading these and thous and the wishes of, this person was this. But what really is a last will and testament? What goes into that document? Well, it's going to direct how your assets that we talked about in the previous slide will be distributed at your death. So it's a communication. It's also a backup document, because if you pass away, something happens and there's not proper retitling, in which we'll get into, then that will must be probated and taken to court so a judge can review it and determine your wishes. And so it's very, very important. The will also can determine your beneficiaries, who receives your items, your personal representative, which is the person that will represent your estate, will bring it to court or whoever the entity may be in order to say this was dad or mom or sister's wishes. And you can also determine the guardians of minor children. So if you have minor children, you definitely want to articulate who you want to be the guardian in case something were to happen to you. The will only pertains to the distribution of your assets titled in your name at your death. So if they weren't titled in your name at your death, then the will doesn't pertain to it. So if you bought a car, a blue Chevy in 1979, and now you don't have that car, but it's still listed in your last will and testament, it's no longer that particular asset is no longer valid.
Mhm.
If there are titled assets without POD, and that's paid on death, or TOD, transfer on death beneficiaries, then there's the possibility of probate. And your will step in, the will govern, again, like we talked about, it will be probated. So we'll talk about this a little later, but you want to be sure that your assets are titled with a transfer on death beneficiary or a paid on death beneficiary. You get that on your bank, and other documents, which we'll get into later. And with the last will and testament, you can still control how your assets are distributed. So you really want the last will and testament so you can articulate how you want things done after you pass away. And if you have minor children, like we discussed before, you want a guardian designation for your children. And some people even have guardian designation of pets, believe it or not. Some people, they have their fur babies and they're like, well, I don't want my fur baby to go to the Humane Society. I really want my sister to care for it. And these are the methods in which I want, my sister to care for my fur baby. So going right into it, what is probate? I talked a lot about probate. So I'm just going to give you an overview of what probate is. And again, it's a court process in which the court determines the last will and testament of a decedent. So they take the last will and testament and they say, is this valid or invalid? So the will must be valid. It has to, in Missouri, have 2 signatures from disinterested witnesses and be notarized. And then on a person's death, his or her will, it'll be produced. Like I said, the judge will review it. And any property that he or she owned, an interest will be transferred to the person entitled to it according to the last will and testament, if you have one. So again, the last will and testament is like a backup document. It tells the court exactly how you want things done if your items are not titled prior to you pass away. Now, probate, it can take 9 months or more, depending on your assets, the value of your assets, which assets you have, the ease of distribution, if there are, heirs down the line that are entitled to it, how those are distributed. And it could be supervised or unsupervised. So that's going to be determined and outlined in your last will and testament, whether or not it would be supervised or unsupervised, or with a bond, without a bond. But if you don't have a will, still go to probate, and more than likely you will go to probate if you don't have a will. The thing is, the probate court can't determine your wishes because you don't have a writing. So what they do is they determine the rightful heir according to intestate laws. So they determine who's entitled to your property according to the laws of Missouri. So you have no control at that point after you pass away. Your personal representative, someone must be appointed if there are untitled assets out there that, may be foreclosed on, or, contracts or bank accounts need to be closed. A personal representative can bring this to court to handle the affairs and then get those assets distributed to the rightful heirs. Now, again, the court would make that determination. And without a will, again, it's a little bit more difficult because the court does not know your wishes. And so they have to go through your whole family history and figure out who passed away, who's still living, who's related to who and how. So again, it can take 9 months or more, depending. So you want to eliminate that. You really want to eliminate that because you don't want your family to go through that. I deal with probate all the time. And the biggest thing that I hear is, for example, mom passed away a year ago. Why am I still having to deal with this? When is this going to be over? I just want to grieve and move on. But we have to wind up all these affairs, unfortunately. And so in order to avoid this is why we get an estate plan. Now, you can have non-probate transfers, meaning things can transfer outside of probate if you have payable on death and transfer on death beneficiary designations. So if you have a bank account, you want to be sure that you go to the bank and you get a beneficiary on your account. If you have life insurance, 401ks, if you own property, all those assets we talked about, you want to sit down and speak with an attorney so you can figure out how you can retitle those prior to something even happening. You can also obtain a trust. And I'll go into more about what a trust is later on, but essentially it's an entity to hold your assets. So it's another way of retitling so those assets do not go to probate. And these are, of course, some of the things that you can retitle: your home with the deed, car, accounts, contracts, if you have real estate contracts, things of that nature. And what is a trust? All right, so I think of a trust as a vehicle. Think about a trust as like a holding vehicle for assets. And if you want assets to be distributed later down the line, for example, to your grandkids or to your children or to your nieces and nephews or whomever, even to a charitable organization, you can articulate that in the trust. You can open up a trust account. You can put your funds or your assets into that trust. And in the trust document, you're going to outline, similarly to the will, but in a different way, you're going to outline who would have access to those items that would be titled in the trust, because the trust can live on after you pass away. I generally recommend a revocable living trust for your lifetime and the lifetime of your survivor. With a revocable living trust, you can transfer items in and out while you're still alive, but upon your passing, then it stops. Then no one can transfer anything in and out other than articulated. So for example, if you wanted for your grandchildren to have their distributions at 18, 21, 23, 25, you can outline that, and they will get that percentage based on the trust. So why would you set it up? Because it's a great way to transfer assets without that retitling. And so you don't have to worry about it going to probate. It's in the trust. It's going to be kept safe until that specific time in which you outline. It's also a way to reduce taxes. Again, I'm not a tax advisor, so I can't provide tax advice, but a trust is another way to reduce your taxes. And if you have a business, it can help you manage the succession of your business. So if something were to happen to you and you are the primary role in the business and you pass away and the business has to dissolve, it can show the business how to manage the succession of that, how to cease business and distribute assets. All right, so after the trust, let's come back to the future and talk about incapacity planning. Because if you're incapacitated, you still may need some assistance. And there are several ways to do this. So for incapacity planning, you want to be sure that you have a durable power of attorney for your finances and your medical. So what's a durable power of attorney? It's an agent that acts on your behalf, that speaks for you. But it's put into a document in which the bank, for example, can see this document and know that your daughter or your son, whoever you nominate, can go in and handle your finances in case you become incapacitated. They can go in and pay your car note. They can go in and pay for your care. A durable power of attorney for medical is that they're the agent for you, which means they're going to follow your healthcare directive, but they're also going to communicate with the doctors and things to make sure that your care is up to par. They're making the right decisions for you. So this person is someone you absolutely should trust, the durable power of attorney, because they're the agent. They're speaking for you in the case of your incapacitation, in which you can't communicate your desires. And then you have your healthcare directive or your living will, and that document is actually going to outline your wishes for incapacity. So if you do not want to be resuscitated, or if you have dementia and want food withheld, or if it's against your religion to have a certain procedure done, you're going to put all this in your healthcare directive and provide it to your primary care provider so they understand those wishes. Additionally, the HIPAA waiver is another document in which in the healthcare industry is very important. You want to have the HIPAA document completed because you want to list individuals on that document that can learn about your private health information. So if you want your daughter to be able to call up to the hospital to find out how you're doing, you want to list her on that HIPAA. Whomever you wish to find out that information, you want to list them on that document. And lastly, you want to be sure that there's some sort of disability insurance. Um, and again, I would recommend you talk to an insurance provider, but what disability insurance does, if you do become incapacitated, that can kick in and help support you. So you're not having to go into your savings, family isn't having to come up with a whole lot of money for your care. You already have that set up that you've been paying on. So the disability insurance will kick in and start paying those expenses for you.
Mm.
Financial planning and retirement is a big piece of estate planning. Again, I'm not a financial planner, but I highly recommend that you speak with one. I work with financial planners and advisors when I speak with my estate planning clients because they know their financial picture and they can communicate that to me. They may know about accounts that I don't know about. They may know how to, extend the length of certain insurances. And so you want to be sure that your current plan for retirement is sufficient, and if not, determine who you need to talk to make it sufficient. If you need to set up another life insurance policy, if you need to, put in more money in your 401k, and then revise your plan with your A team. Your A team can be your spouse, it could be your accountant, it could be your financial planner, it could be your daughter, whoever helps you. Develop that with them so they can understand your wishes and understand what that's going to look like long term. And again, we highly recommend you speak with an attorney about incorporating your financial retirement plan with your estate plan because that's a big part of it.
Mm.
So I talked about a ton of different things. So, okay, so what does estate plan include? So when you sit down with the person, what do you include in your estate plans? What does it look like? Well, we sit down and we talk to you. We counsel you regarding your assets, what you currently have, even if you only have a bank account. We're going to talk to you about what that looks like, the different scenarios that can happen, and how you need to adequately prepare. Generally, we include in our packages with an estate plan the last will and testament, again, the guardianship appointment of your minors and pets, trusts, your durable power of attorney for your finances and medical, your HIPAA release, healthcare directive, deeds for any property. We talk to you again about retitling any assets that you currently have or that you may gain in the future. We talk to you about your current insurance, what you have, what you anticipate that you may have in the future, what those policies look like. And we can also help you in the entity creation. So if you don't want to create a trust, some people set up an LLC for certain reasons if they have properties that they want to distribute throughout their lifetime. So we'll talk to you about that. So an estate plan is just not a one document thing. Like we talked about earlier, we sit down and talk to you about everything. It's holistic, it's encompassing. What's going on in your life and what are your plans for the future and how do we adequately prepare you for that? So the process is easy. I know you've seen a whole list of documents on the previous slide, but the process is easy for you. The biggest thing is the consultation, sitting down and talking to a lawyer and being open about what you have. That's a time to be open and communicating what your wishes are. Then we go back to the table with that information and we draft your documents, whatever that may be, whatever we decide, mutually upon that you need for your plan. You'll review it, we'll go over it, we give you a summary, we talk to you about it, what these things look like. And then we sit down and have a signing ceremony in which you sign your documents in front of two disinterested witnesses and a notary. Then we copy the documents for you. We urge you to implement them and store them in a safe place. So if you have a last will and testament, of course, store it in a fireproof safe or somewhere safe. Give certain documents to your doctor or a PCP. And then we urge you to review after any life-changing event or after every 5 years, because generally after every 5 years, something's changed in your life. You may have acquired more assets, you may have lost assets. Just talking to you about, your current plan and if that plan does or does not need to change. So with all that being said, it is question and answer time, and I know you may have a ton of questions, but I will open the floor for anything that anyone has.
Thank you so much, Attorney Haymon. What questions does everyone have for her?
We have a question here at Dunn Road. Go ahead, Ms. Phyllis.
I want to know about the power of attorney. You just only have one person, or can you have two?
Can you have one or two powers of attorney is the question.
Yes, you can have one, you can have two. We always recommend that you have two. One primary and then a successor.
Okay.
Yeah.
Okay, now what about your bank account? Okay, can you have two on there, or you just have one?
For your bank account, can you have two on that?
You certainly can, but I urge you to think about that. So if you have two individuals on your bank account, make sure they get along and make sure they understand your wishes on your bank account, because you can have two people on there as co-agents, or you can have, like we just talked about, a successor agent, meaning you can have a beneficiary, and then if something happens to them, then the other person will kick in.
Thank you.
So,
Mm-hmm.
I have two on my bank account also, and I was wondering, I also have two on my insurance policies. Well, how would that work?
Did you hear that question?
No, we didn't, Leanne.
She said she has two people on her bank account and two on her, what did you say? Your life insurance?
Insurance, life insurance.
Yeah.
policy.
So she's wondering how that would work. Are they the same
My sister and my daughter.
for both accounts?
Yes.
Okay, and they're the same for both accounts.
Okay. So that, I mean, that should be fine if that's who she desires, but I would have to look at the particular situation.
I want to piggyback on that. Should you have one specifically designated as primary?
She can. And it's really going to be up to the family and the situation. So a lot of times I know for myself, I know, you know, with my mom, I'm the only one on there. But with my dad, my sister and I are on there together. And we have an understanding that if anything happens jointly, you know, where that goes. So it's really going to depend on the situation.
If you want to, or did that answer your question? What specifically did you want to know about that?
Yeah, because the insurance company asked me who did I want first,
Mm-hmm.
you know, to sign off on. So I guess I can take a look at that.
Mm-hmm.
Yeah, I'm good.
Okay.
Yeah, because I got my daughter, my son, and my granddaughter on my insurance. Yes.
For a beneficiary?
My daughter's a beneficiary, and then primary, my son and my granddaughter.
Okay. Yeah, she said she has three on hers, on her life insurance.
Okay.
I'm piggyback on that again. Should one have a percentage of what is going to whom, or leave it open? But like you said, I think I understand when you sit down and talk to the one who's helping you, that's when you make that decision. Let's say like you have 3 houses. Do I want 2 houses to go to my son, or 1 house, you know, to go to my son? Or
Mm-hmm.
that's decided when you sit down with the person that's helping you.
Yes, ma'am.
And Attorney Haymon, I have. Oh, sorry.
I guess that was a statement, wasn't a question.
Attorney Haymon, I have a question. So does it, as far as the power of attorney for medical and financial, is that okay that if that's the same person? Is it sometimes better to have separate people doing that in your experience?
It's really going to depend on your individual situation. I have some clients who are the same on both. I have some clients that say my daughter's better with money and my son's better at making my health decisions. So my son is on my health, my daughter is on my finances. You know, so it's really going to depend on your situation and the strengths of the individuals that you choose.
And that durable power of attorney, they're still supposed to make decisions based on what you want, correct?
Yes, ma'am.
Okay. 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 Does anyone have any other questions for Attorney Haymon?
Did that answer your question as far as your, okay, yeah. Anybody, anything else on our end? No?
Okay, well, I thank you. We've got Attorney Haymon's contact information here. So all of her information is here, and I'll also be sure to get this sent out to you via email. So you have that information, not only for you, but also some family members and loved ones that you know too may say, hey, I'd like to find out more. I'd like to get more information too. Because as Attorney Haymon says, I think we all just need to be prepared. I've just heard so many stories about people, when people are no longer with us and their affairs are stuck in, and I've heard of stories, as Attorney Haymon said, where their affairs are stuck in probate. And it was like, oh, I thought I was just going to automatically get it. And it doesn't work like that so often. Mm-hmm. And so people are still, and I remember my mother said, it's so sad that people have to spend money now because they have to get a lawyer and spend money to get, if they had planned it out, they wouldn't have to go through all of that if they had done the work up front. So, yeah.
You're right, Ms. Sims, because, with probate, an attorney is required. Mm-hmm. Like, they won't let you go through probate without hiring an attorney. And it's going to be based on your assets. So for me, I always urge my clients, go ahead and spend a little bit of money now on estate planning. So your family isn't paying me 3 times that and what it costs to wind down your affairs after you pass away. Let's just get it done now. Make sure everything's right. So nobody has to worry about anything. You're not holding car washes and selling T-shirts in order to bury your loved ones and, going through probate and just taking away from the time to grieve and get back to normal.
I just had a question.
Yes,
mm-hmm. Not May, because I know I can't. I could write a letter designating everything I want to happen, where I want it to go, and with stipulations. Could that be legally good enough? I put that with my insurance policies or with everything I own. I have a safe deposit and I just put it in a safe deposit box. Would that be good enough?
In all honesty, I'd be remiss if I said yes, because that's not going to be entered into probate in case something wasn't properly titled. So your wishes won't be communicated. That generally won't be entered into the probate. So no one will see that but your family members. But it's always good to have a letter articulating your wishes. We generally include a letter of last instruction, just letting people know this is what I want. But you also want that last will and testament and all the documents that I just talked about, because those are the documents that can legally be used to govern your assets. That letter probably won't be utilized in any capacity.
Mm-hmm. I got a question. How if you get it notarized? It wouldn't be?
It's still not a last will and testament. So when we go to probate, the only thing that the judge wants entered is the last will and testament. If you don't have that, and it's intestate. And so it's going to be governed by the laws of Missouri. Even if you want, your vacuum cleaner to go to your sister, it's not going to matter if you have children. They're going to get it. So even if you have it notarized, it's not what Missouri law wants, so it won't be entered into probate. Now, it will help your family understand what you want so they can argue it for you or try to get the assets where they need to go, but it won't do much as far as being admitted into any court process or any process to obtain any assets at all.
Well, I have mine out everything in writing, but I just have one child, so I want to go through everything.
So you're saying, like, is it necessary?
Yeah,
Okay.
yeah, with just one child.
It still is necessary, because I hate to say it, if something happens to your child before you, then who does it go to, and you want everything articulated, because if it's left to, your child and their heirs, and at least you have that put in writing that their children would get something. And it won't, you know, go to probate and go to cousins and uncles and all that.
Yeah. Yeah. One thing that I found that was really kind of interesting was that there's some people that just, and as Attorney Haymon has said, I know all, you know, we just tend to think it's just going to go to family members, but I just know because of the experiences I've had with some of my family, we just assume we just do it like this, it wouldn't be a big deal, like for land and different things. And because we didn't have those forms like she mentioned in place, they got stuck in court where they had to get lawyers, and took months and months and months to get all that straightened out. And, you know, we just assumed that, you know, we just stay within the family or we just go certain places. But because there wasn't any formal paperwork for houses and land and different things, it just ended up being a lot of money. And that's when we learned, okay, you gotta have these forms in place, because if not, it will go through the process. And it's amazing to think about even people that have had lots of money. When you think about like the guy that did the Black Panther movies that passed, his stuff is now in probate court. He was married. And so you just assume, well, his wife will get it. No, he's in probate court right now, trying to get his assets. You think about people like when Prince died, he didn't have anything. His family had to go to probate court. You know, these are people that have lots of money. You think, yeah. So I always think about the guy, Chadwick, I can't remember his name, the guy that did the Black Panther movie, that his wife is now in probate court. You would just assume that she would get it, I thought. And so, you know, you just have to go through that. So that's why I think this topic is so important, and that people just should be knowledgeable, you know, about what's really necessary to make sure their wishes are carried out. So.
Absolutely. And thank you for those examples. You know, you hear about that all the time. Even Ike Turner, I talk about Ike Turner. You know, Ike Turner had a lot of women. So it was a lot of women in probate court trying to say that they deserved his money. And that went on for like 9 years. And he came out, he had all these kids and carrying on. Like he could have kept all of that under wraps if he would have just had his estate plan. So, you know, 9 years later, you got kids coming out the woodworks fighting for your money that you didn't even know you had.
Yeah. 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 Well, I thank everyone for participating today. We thank Attorney Haymon for her time. We've got her contact information here, and I'll make sure and get this information out to you as well.
Thank you.
Thank you so much, everyone.
Thank you.
Oh, why did that happen?
That was very good information. We thank you all. Thank you for participating.
Thank you.
Thank you. Have a blessed day.
Thank you. Thank you, Attorney
Thank you.
Haymon.
All right. Have a good day.
All right. Bye-bye.
All right. Bye.